All right, we're in the matter of the State of Indiana in the relation of Honorable Sonia Morris, Judge of Chicago City Court versus Gilda Orange et al., 45 C01, 1302 PL 12. And we're supposed to get Mr. Mulvaney on the phone. Is that what we're doing?
That's correct, Your Honor.
Okay. You gentlemen might want to step up here so we can be sure that we are here.
Good afternoon, State Green Vessel.
Mr. Mulvaney, please. Mr. Mulvaney, this is Judge Parrish of Circuit Court in Lake County. We're here. How are you?
Okay.
I have all the parties present. Would everybody identify themselves for the record on this?
My name is John Schwall on behalf of Judge Morris.
I'm Scott Shin on behalf of all the defendants in this case.
Attorney Stephen Lauer on behalf of all the defendants also.
And we have Mr. Mulvaney telephonically. All right, are we ready to proceed? We're here for, we have a motion to stay. Any further proceedings, and we'll take a motion today on that summarily rule.
That's correct. We'd also filed a response, Your Honor.
Okay. All right, you ready to proceed?
Sure, Your Honor. Well, again, Scott Shin, Baker Baker Law Firm on behalf of the defendants. I think it's our motion to stay, so if you could please support, I'll also make a few remarks. I think clearly all the papers now are in front of the court from which you can make a judgment. We have filed, I think probably as important as a notice of appeal of the judge's order of mandate and judgment. As part of that process, we have filed this motion for stay of the effectiveness of the court's judgment and mandate, specifically a request that the court stay its order to the council to appropriate the funds, the $65,000 funds as mentioned in the court's order. I'd say three things in support of that motion, Your Honor, if you like, and doing that would say a few things in response to the papers filed by the defendants in this case. First, clearly, we assert that we have a potentially meritorious appeal. Of course, it's on that basis in part that we seek that stay. We also want to talk about harm or argue a lack of harm to the plaintiff from a stay, and in that regard, the way in which in our papers demonstrate that we'd like to find an accommodation so that there in fact can be no harm. And then thirdly, how we think the precedent, including recent precedent, just in 2013 from the Indiana Supreme Court might bear upon some of the legal and procedural questions in this case that would be addressed on appeal, specifically the applicability of 16.5. So on the first point, the merits, just very briefly, because you sat through the trial, Your Honor, I didn't, so I'm going to rehash that for you and for counsel to my left and right. But clearly we have evidence in the record about certainly comparative evidence about the costs incurred by the Chicago Circuit Court and in comparison to other similarly situated jurisdictions, and it's quite a bit higher than that. It's competent evidence that was introduced, and it's evidence that we'll rely on, certainly on the merits. And we would point out that that alone gives us some likelihood of success on appeal. I again won't rehash that. The second thing I'd point out is this notion of what is the harm to the court, to the plaintiff, if a stay is granted. And the harm, I think, is virtually nothing. First of all, we're talking about the rest of 2013. We're at the 2013 budget here.
Before you go on,
Sure.
I read that letter that he attached from the controller.
That's correct, Your Honor.
It's all like the controller was going to start cutting her budget and telling her to lay off employees or things of that nature?
Well, but here's a way around that, I think. And I think the papers on stay reflect this possibility. First, in paragraph 4, Your Honor, of your order of mandate and judgment, you suggested that although you were issuing a mandate, that your review of the statute regarding the adult probation fund, specifically 35-38-2-1H, showed that those funds were available to augment probation salaries, not just, for example, non-salary expenses of the office, as I think had been argued earlier in the case. Added to that, the explicit reference in our motion for stay that it's the council's position. They have no objection whatsoever, especially in light of the court's finding in that regard, to the use of those funds yet in 2013 for the court's use. And third, let me flag this because this is not record evidence, so you give it only the way that it's due back. But I wondered if we could get something of a stipulation about this. For the 2014 budget, so not the 2013 budget that was an issue before you in this case, but the 2014 budget that's just been passed, the city court judge has proposed a budget that includes reliance on that adult probation fund, at least to the tune of $20,000, to augment salaries. So at least that issue, to the extent that it was an issue before you, seems to be going away. Final thing I'd say about that is, so just to be very clear, those funds that are in the fund and available to the court for use, to the city court for use, may be used for salaries in 2013. And if it turns out, and this again was our position in our motion for stay, if it turns out we're wrong, we just get it wrong, and an appellate court tells us that we're wrong about that, the city council can always replenish those funds to the tune of whatever is spent, or the whole amount of the mandate, the whole $65,000, if that is used up by the city court judge. So I think there is no realistic harm at this stage, given the availability of those funds. The final thing I said, and I'll wind up because we want to obviously keep you on this. The Supreme Court's decision. Now I'll say in advance that Mr. Mulvaney, I'm sure will have something to say about this because he was one of the counsel of record in this case. But in the recent June 2013 decision, the Marion County Small Claims Court, and something he did, a citation to that. But in that case, Justice Rucker's thoughtful and early decision mandate action for these things, I would point out that it suggests, I think, very clearly that the city of Gary engaged whether or not it applies. The real reason to think that's no longer that the Indianapolis Marion Small Claims mandate was a case involving Marion County Township Small Claims. Since the Marion County, or Bryan Township, they are not in any way overseen by the Circuit Court. They are independent courts at the county court. They're very analogous to how not part of the county court anyway. And yet, Justice Rucker's opinion says to confer it clearly applies to Rule 60.5. That decision, right? In the end, that was 60.5 case. Secondly, expressly, Justice Rucker said within her power, judges in that case power to issue a mandate under Rule 60.5. So I don't think any question that the Township Small Claims Judge has the power to say or issue a mandate, so can a city court anywhere in the land. And I think the reason that probably 2009 added a layer of more process how the mandate get decided. That various reasons out there that law is now talking about 2009 we now have. So with that, I'd say there's almost no risk in the city court will not have meaningful available support how to take this fund